Good evening, and welcome to this edition of Labor Vision. I'm Bob Delaney, Executive Director of the Institute for Labor Studies and Research. Labor Vision, a production of the Institute, focuses on topics of importance and interest to working Rhode Islanders. We hope you enjoy this evening's edition.
Good morning. I am Frank O'Brien, Director of the Quirk Institute of Industrial Relations here at PC, the host organization. And on behalf of the President, the Very Reverend Brian Shanley, and the administration of Providence College, I welcome you to the annual John H. Fanning Conference on Labor Management Relations. Before we begin our activities, I would like to ask you to join with me in a moment of silence to respect the passing of a good and dear friend and a consummate professional in the field of labor management relations, Charles Ted Schmidt of the University of Rhode Island. Ted and I were rivals in the best sense of the word. Each of us called upon the other many times for counsel and support, and I shall miss him dearly. Ted will be laid to rest later this morning, and I ask you to remember him in your prayers. Please join with me in a moment of silence. Thank you, and I should also point out that Ted is a former awardee of the Fanning Conference. And so with those preliminary matters taken care of, I'll call upon our first panel.
Welcome. I'm Jerry Visconti. I'm going to moderate this very exciting topic, security of collective bargaining rights in relation to the judicial system. So I'd like to call John Tarantino for the first presentation.
Thank you. Good morning. Again, my name is John Tarantino, and I'm representing the defendants, the governor, the treasurer, the employees' retirement system, the state, in litigation that has been brought by a number of unions, labor unions, against the state, challenging legislative amendments that were made to the pension laws back in 2009 and 2010. In your outline, it goes into detail what the specific changes are and how they affect the various persons who are the beneficiaries of those pension changes. But what I want to focus on is what the arguments are in the case, the legal arguments are in the case, for both sides, and what I've tried to do, it's very difficult for me to do this, but I've tried to do it in the best way that I can to lay out the plaintiff's arguments and then contrast them with the defendant's arguments. Obviously, the plaintiffs are very, very well represented by Lynette Labinger. I'm sure she would do a better job of explaining the plaintiff's arguments than I would. But I think I've pretty much captured what the plaintiff's arguments are. And then I'll talk about the defendant's arguments, what the legal issues are in the case, what rulings have been made to date, and what's remaining to be litigated and tried. So let me begin with the plaintiff's arguments. Again, remember there are two acts, 2009 and 2010, both of which made changes to the pension system, dealing with, retirement age, benefit age, cost of living adjustments, and the like. And the plaintiffs filed the lawsuit and argue that the 2009 and the 2010 acts both violate the Rhode Island Contract Clause, the Rhode Island Constitution, and the Takings Clause of the Rhode Island Constitution. And I just want to stop there for a moment because I think this was a very significant decision that the plaintiff's counsel made in this case, and from my perspective, a wise decision, because they sued only based on the Rhode Island Constitution. I had been involved in some other litigation brought by unions challenging other statutory amendments just a year before. And in that case, the unions brought very similar challenges, but they brought the challenges under both the federal Constitution and the Rhode Island Constitution. We removed that case to the federal court. Judge Smith got the case, and on cross motions for summary judgment, Judge Smith granted summary judgment to the defendants, accepting our arguments that there was no contract right at issue, because as you'll see later on, there's an argument that it is the job of the legislature to create policy, but generally not to enter into contracts. And Judge Smith agreed with the defense in that case that what these changes were simply policy changes, but there was never an intent to enter into a contract, and the plaintiffs had no contract right. So we'll see how that changes in the Providence County Superior Court. But the plaintiffs made a decision to sue only based on the Rhode Island Constitution. Therefore, there was no basis, there was no opportunity to remove the case to the federal court. And the plaintiffs asked the court to find that there did exist a contractual relationship between the plaintiffs and the state with respect to these pension benefits. And what we did was something very similar to what we did in the federal court, and that is that we asked the court to rule as a matter of law that there was no contract at issue, because once again, whatever rights the plaintiffs had were rights that arose out of statute and not out of a collective bargaining agreement. Later on, when Joe Penza talks about his case, the City of Providence case, that's a very different case, because there's a collective bargaining agreement or several collective bargaining agreements which clearly are contracts. So there's no question you're dealing with a contract. There's no question you're dealing with changes to contract and what legal, rights or remedies flow from that. In the state case, there is no collective bargaining agreement between the state and the union members. There's a statute that sets forth what certain benefits are, and that statute, as we laid out in our papers, has changed many times, many times over the years, and this was one additional time that it changed. So we moved for summary judgment on the grounds that there was no contract right at issue, and not surprisingly, even though we cited a number of cases, we cited the very recent decision by Judge Smith that had only come out several months before, saying there is no contract right because a statute doesn't create a contract right. And there's something in the law, it sounds sort of intriguing or mysterious, but it's pretty simple. It's called the unmistakability doctrine. And all the unmistakability doctrine is it says that if someone is going to rely on a statute to claim that the statute creates a contract right to benefit that person or group of persons, then it must be unmistakably clear in the words of the statute itself that that is what the legislature intended to do. And the United States Supreme Court has said the reason that the unmistakability doctrine exists is, A, it is the job of the legislature to create policy and law, but not contracts. And it's unusual that the legislature sets forth to establish a contract in the first instance. And two, if you were to find the existence of contract, it really hamstrings what other legislators can do in the future. You're basically binding future legislators to what legislators at one point in time did, and that would be inconsistent with Republican small r, Republican form of government. So they sounded like pretty good arguments to me, and they were accepted arguments by Judge Smith. But when we made those arguments in the Providence County Superior Court, Judge Taft-Carter, who I think is a very good judge, and Judge Taft-Carter, if you read her decision, it's a very well written and reasoned opinion. I respectfully think she got just the most important part of it wrong. But, but other than that, I liked it. But here's what she ruled. She agreed with the defendants, my argument, that the unmistakability doctrine controls. She agreed with that. And she looked at the legislation, as we had invited her to do, and she agreed that there was nothing in the statute that would lead one to believe that it was the intent of the statute legislature to create a contract. There was no unmistakably clear language that that is what the legislature was trying to do with these two acts. Again, sounds pretty good to me.
And then for the rest of the story.
And then for the rest of the story. And just to give you, just again, to see some examples, there are cases where courts have ruled that the legislature did intend to create a contract in a statute. And we cited those cases, and we contrasted them with this case. In those, for example, there's a very famous case where 123 times in a statute, the legislature said, contract. We're intending to create a contract. That's pretty unmistakably clear. But she ruled that there was no such language in this contract. She said that doesn't end the story, though. And she said that she could find there is such a thing in the law as implied contract. And there is. For those of us who went to law school, we all remember from first-year contracts that you can have an express contract, a written contract, or you can have an implied contract. That's pretty clear as well. And what she determined was that even though there was no express contract based on the unmistakability doctrine, she determined that there was an implied contract, that certainly, why would you have these statutes if the legislature did not intend to imply the existence of a contract? Again, very respectfully, I disagree with her, because if you allow for implied contracts, then you swallow the unmistakability doctrine. In every statute, one could say, well, why did the legislature draft this statute? Well, maybe they drafted the statute because they intended to create a contract. That may be. But what the unmistakability doctrine does is it takes away all of that. Well, let's try to figure out what the legislature did. Let's actually read what they said. And there are a number of cases that the parties didn't brief this because we didn't know how Judge Taft-Carter was going to rule, but there are a number of cases that say you cannot apply traditional contract principles and the unmistakability doctrine at the same time. Why? Because by doing that, you eviscerate the unmistakability doctrine. We asked the Rhode Island Supreme Court to review on a petition for writ of certiorari that question. They declined to do it. They declined to rule on the petition without prejudice, saying basically this is something that you can raise in the litigation before Judge Taft-Carter in what's remaining in the litigation. So it will be one of the principal legal issues that the judge will have to determine in the case, and that is, can you have such a thing as implied contract and the unmistakability doctrine at the same time, or does one eviscerate the other? But she has not ruled on that. That's an issue that we're going to have to argue and debate, and I'm sure that Lynette, who's a very good friend of mine and a great colleague and a terrific lawyer, will have some interesting arguments to make. So what's left in the case? Well, the only issue that we have litigated is there not a contract? And at least for present purposes, we have to proceed on the grounds that there is an implied contract in each of these statutes. Again, that doesn't end the story either. There are two other things that need to be shown in order for the plaintiffs to prevail. And this is based on a Rhode Island Supreme Court law that says, what are the defenses to impairment of contract? Most of us might think, certainly I did initially, that if you have a constitutional provision that says you cannot impair contracts, that's pretty clear. It's black and white. If you have a contract, you can't impair it. the law is actually not so black and white. It's sort of different shades of gray, and particularly when you're dealing with the state or municipalities. And what the law says is that you really shouldn't impair a contract. You're not supposed to impair a contract, but there are cases where the state or a municipality may impair a contract and not violate the Constitution. One, you first litigate, is there a contract right? Well, we just talked about that. The second issue is, has the contract right been substantially impaired? So not every impairment would be considered a constitutional violation. There has to be a substantial impairment. And I know that's an issue that Joe will talk about in his case, whether that's really a question of fact. Is it a question of law? Are the facts so clear that one could say as a matter of law it is substantial or not? Those are things that haven't been litigated in our case yet. And then assuming the plaintiffs get by that hurdle, meaning they can show a substantial impairment, to me the most important issue in the case, legal issue, the one that I think will be the core issue, is there a legitimate public purpose to justify the impairment? So assuming the court would find, either as a matter of law or based on the facts, that there is a substantial impairment, the last issue is there a legitimate public purpose that would justify the impairment? Now, like, beauty is in the eye of the beholder. You've all heard that. Well, what's a legitimate public purpose is also probably in the eye of the beholder. From the state's perspective, we will argue, and I'm not divulging any secrets. This is pretty clear. We're going to argue that yes, there's a legitimate public purpose behind these pension changes, and basically, if you don't change the pension system, there's going to be economic disaster. Now, my friend here, Donald, will say, I'm prone to hyperbole, that's not true, we can work through these things, and I will tell you that I am a big believer in working through things. I think that is the way to solve the vast majority of problems, and I hope every case can get worked through. But there are some times you actually need to have a court rule. And this very well may be one of those cases where you just have to get the court to rule. So we'll see how that works out. I thought the same thing was going to happen in Joe Penz's case, and I was surprised. So we'll see what happens. But the court will have to determine, based on the evidence that is presented by both sides, on why were these pension changes made, what was the justification for them, what kinds of alternatives were looked at, what kinds of options were available to the state before they implemented these pension changes. Really, did they really need to be made? Is there a legitimate public purpose behind the pension changes? I believe if the court ultimately determines, I'm not saying which way the court will come out, I certainly can tell you the way I hope it comes out, but if the court determines that there is a legitimate public purpose, then under the law there is a justification and there will not be a deemed constitutional violation. If the court determines that there was not a legitimate public purpose, then more likely than not the court is going to determine that there is a violation, and then we'd get into the remedy phase. So there's a lot more to this litigation than sort of that brief summary, but if you take away that summary, you'll be able to talk about this case at cocktail parties and things. So you'll have enough summary of what's going on. And where we are now is that we are in what I call phase 2 of the litigation. The contract right has been determined. And we need to get into discovery and either teeing up the matter for what I personally believe will probably be cross motions for summary judgment, because I don't think the facts are going to ultimately be significantly in dispute what happened here, but they might be. And if they are, then there would be discovery period and then a trial before Judge Taft-Carter on the merits. So that's my summary.
Thank you, John. Joe Penza?
Thank you, Jerry. My name is Joe Penza. I'm representing the retirees in the city of Providence, what we call the Class B retirees, who are the police and fire. And I have to thank John for actually doing my homework for me, because I've been engaged in mediation over the last 2.5 weeks. I was actually getting ready for trial in this case. My case started out as an issue as to whether or not the city of Providence could change the Class B retirees' health care benefits under the collective bargaining agreements that were in place going back as far as the 1970s. Police officers and firefighters who retired were guaranteed, and I put that in quotation marks because that's a word I no longer use in these areas of labor contracts, guaranteed their health care benefits, Blue Cross, for the rest of their lives. In June of 2011, June 30th to be exact, the state legislature enacted, I believe the history shows at the behest of City of Providence officials, the the statute 28-54-1, which provided that for employees in any municipality to continue to get their health care benefits, if the municipality so desired to switch them over to Medicare, they were going to be compelled to switch over to Medicare. And the key words were notwithstanding any interest arbitration award, collective bargaining agreement, or ordinance to the contrary. Armed with that state enabling statute, the City of Providence then passed an ordinance on July 18th, 2011, which mirrored the state law and said that all of our retirees, fire and police, who are currently receiving paid Blue Cross will be compelled to switch over to Medicare. Under the ordinance, the city agreed to pay for what is called a supplemental coverage. Turning 65 in September, I didn't know how I was going to learn about Medicare, but I guess I got paid for doing it. So there are 4 parts to Medicare. There's Medicare Part A, which covers hospitalization; B, which is generally doctor visits and outpatient procedures; C, which is a supplemental insurance to pick up what B doesn't; and D is the prescription phase of it. The city agreed to pay for B. A is free, essentially, as long as you qualify for Medicare, which is you have to have 40 quarters during your lifetime. Some police officers or firefighters don't, because if they never had another outside job, they didn't have Social Security benefits. So those people are actually separate and apart from this litigation, because they're going to continue to receive their health care benefits paid for by the city through Blue Cross. But the majority, and there are 1,300 retirees involved in, not in the initial litigation. The initial litigation only involved those who were 65 and older, which amounted to about 625, 650. So after the statute was passed, we actually didn't do anything until suddenly in October we heard rumblings that the city was going forward. We filed a lawsuit, declaratory judgment action, and I, like John, figured, well, until I got into this, I said, well, you got a contract in place, so you can't violate the contract. The contracts clause says government can't interfere with contracts, and then, as John said, it's not black and white, it's definitely gray. And I then had to dust off my law school books from 40 years ago and start learning about constitutional law and contracts clause. I thought I was well beyond that. A preliminary injunction hearing was held because there was a group of retirees who were already enrolled in Medicare Part B. And you may say, well, why did they do that if they already had this coverage from the city? I was told, I was kind of surprised that there were any, because it was costing them $100 or so per month, but they used it as a supplement, because actually under Medicare Part B, there's no copays. You actually get rid of copays and stuff like that. So they combined with the city plan, they could actually get the benefit of a better health care plan. And so that group, consisting of about 350, were going to be switched over into Medicare as of February 1, and they were going to lose their city-paid health insurance on February 1. That triggered an injunction hearing, preliminary injunction hearing before Judge Taft Carter. It went over 8 or 9 days. She's on the formal and special cause calendar, so she can't devote full days, so we were doing half days here and there. With the Christmas holidays, the actual hearing didn't finish until January 4th or 5th, I believe. Briefs were submitted, and on January 30th, Judge Taft Carter granted the preliminary injunction. Unlike John, I was fully pleased with her decision at that point. Of course, the preliminary injunction is not the end of the ball game. The next key date was July 1, because on that date, everyone had to transfer over who was currently on the city-paid health care plan to Medicare, and if they didn't do it by July 1, 2012, the next enrollment date for this group would have been July 1, 2013. So the judge was concerned that the city was going to lose $8 million of savings, and so she asked us to fast-track this. And I didn't think it was any big thing. I figured we could definitely get this ready in 3 months until we started doing the discovery. And even though everyone cooperated, Bill Dolan is representing the city of Providence, a great guy, great attorney, and someone I enjoyed working with. We both have the same philosophy. We argue about the things you have to argue about and get by the little stuff and treat each other with a great deal of respect. And so even though we agreed to fast-track it, it became obvious as we were going through this process that this was not something that really should be done in a 3-month time period. John is going to have 2 or 3 years probably before he fully has all the briefs written and arguments made and the decision rendered. We had 3 months to do all pretrial discovery. One of the issues, as John mentioned, is the legitimate public purpose. And actually, Judge Taft Carter, in that decision, found that under the city ordinance that the city did in fact have a legitimate public purpose because of the financial straits it found itself in. She found that there was a contract. As John mentioned, we didn't have that issue because we all had collective bargaining agreements. She found that there was a substantial impairment to those contracts. Now, that became an issue. Bill Dolan, I thought, was very creative in this, although I don't think he would have eventually prevailed on it. He was taking a tack that I had never seen in any of the 50 or 60 cases that had decided contract clause cases, and he was contending that substantial impairment might be different for someone who was making the poster child for these COLAs was someone who was a retired chief and 6% compounded is up to $195,000. The fact that he might be switched over to Medicare may not substantially impair him as an individual, but someone who is making $25,000 or $30,000, that would be substantial impairment. The cases generally look at what right is being impaired and whether it is substantial versus de minimis. Something as little as a 1% decrease in pay has been considered quote-unquote substantial. Something with a 10-delay deferment of your pay has been considered substantial because the courts look at what the contract is and whether that right has been impaired. They don't look at to what the impact is on the individual. I think ultimately, why I think the judge would have ruled in our favor, and we had a pending motion for summary judgment that I think the judge has tucked away in her drawer, why I would have prevailed on that issue is because I told the judge that with respect to this trial, she would then have to look at each of the 650 people who are going to be impacted. I would have to call 650 people to the witness stand, which I know was definitely not going to happen. So I think ultimately on the substantial impairment, you look at what the contract right is and whether it is de minimis versus substantial, and substantial is really not that substantial based on the court cases. One of the things that could be de minimis, the example I gave to Judge Taft Carter, is if the contract provides that you get paid on every other Thursday and suddenly the city, for whatever reason, decides that you should get paid on every other Friday. That certainly would be something, in my opinion, would be de minimis. But other than that, most of the cases have held that any impairment is quote-unquote substantial. Now, After the preliminary injunction was hearing was granted, we go through this fast track of discovery. We have tens of thousands of pages to look at, 20,000 emails. And the reason why we were focusing on that is that, notwithstanding the fact that Judge Tafkata found that there was a legitimate public purpose in the ordinance, she also realized that she had to find whether it was reasonable and necessary, as John mentioned. Under the reasonable and necessary test, there are several sub-tests, if you will. That's how I refer to them as. And it was one of those sub-tests that won the day for us on the preliminary injunction hearing. Ernie Almaty, who was the former Auditor General for the state, actually was on a commission that Mayor Tavares engaged when he first got into office. And that committee rendered a report shortly after Mayor Tavares took office. I think it was February of 2011. And he testified at the preliminary injunction hearing on behalf of the city. His testimony went into great detail how bad the city was financially, and therefore gave the basis for Judge Tafkata to find that there was a legitimate public purpose involved. But on the reasonable and necessary, on cross-examination, rather than focusing on the city's financial plight, I focused on how long the city was aware of this. And I got him to agree with me that it was going back to the 1980s that the city was aware that what we call the other post-employment benefits, referred to as OPEBs, was going to be a thorn in the city's side and had grown to the figure of $1.5 billion. That's separate and apart from the pensions. The OPEBs are other post-employment benefits, predominantly health care benefits. And based on his testimony and the documents that we were able to introduce at the preliminary injunction hearing, the judge found that this was not something new and unexpected, but in fact was a chronic problem that went back decades. And notwithstanding the fact that the city was aware of these problems, that they continued to enter into these collective bargaining agreements that provided these quote-unquote rich benefits for retirees, namely continued health care. And our focal point for the upcoming trial was again going to be on when did the city know, because Bill Dolan, I think, was going to argue that this was something that came out of the blue, that essentially the city had balanced budgets, that the state cut back state aid over the last several years under the Kachiri administration, and that, as opposed to what had been told to the city decades before, was the real reason why the city found itself in the financial position it was in. So during the course of discovery, we were focusing on when did the city know to buttress that argument, and it was interesting going through 20,000 emails, my associates did, that they were able to find additional evidence that would have supported that. The other sub-test for the reasonable and necessary prong of the evaluation is that whatever remedy is being invoked by the municipality or the governmental agency trying to impair the contract has to be narrowly tailored. And all of the cases that we read and became aware of, everything was done for a short interim period of time. For example, you had bonds that were that they didn't have to pay the interest on for a year period of time. Mortgages, you couldn't foreclose on mortgages for a short period of time, a year, year and a half. In this situation, our main thrust was going to be that the city did not narrowly tailor its remedy. They were switching people over to Medicare, which was they had a contractual right to pay Blue Cross for the rest of their life. They were switching these people over to Medicare for the rest of their life forever. So that if 10, 15 years from now, the city was back in the black and didn't have a problem, these people's contract would continue to be impaired. So I felt pretty confident that ultimately we were going to prevail on the merits of that case. Some of you may have read recently that the city has indicated that there has been an agreement reached among the retirees, the active, police and fire, and it involved not only that Medicare litigation, but also the COLA litigation, because not too long ago, the city passed an ordinance without the state enabling statute that stopped COLAs from being paid. The effective date of the ordinance was July 1 of this year, but it really wouldn't have kicked in because COLAs are being paid through this year. First real effective date in terms of anybody's pocketbook would have been January 1, 2013. We were about to file a lawsuit challenging that. We had one additional argument in that case, and that is we didn't believe that the city had the right to pass that ordinance without the state enabling act. And I think the city probably learned that the state legislature was not going to pass Governor Chafee's legislative package, amongst which included the ability for municipalities to do what they did in the healthcare, notwithstanding any collective bargaining agreement or interest arbitration, that the municipalities were free to do whatever they wanted with COLAs. I don't think that's going to pass the state legislature, and I think the city probably were aware of it, and I said they probably figured, let's take a shot. I think I saw Councilman Igliozzi here. I don't mean to speak on behalf of the council, but that's my own take on that. And so the city, we were getting ready for trial. Judge Taft-Carter asked us if we had considered mediating it. I told her I would be happy to do so. The city at that point said, look, we have to buy peace, not only on the Medicare, but we know you're going to end up suing us on the COLA. We got to wrap this whole thing up because we are in the fiscal straits that we're in. I said, that's fine, we'll try to do that. Then the city threw another curveball at us, and they said, oh, and by the way, you guys have to also bring in the active police and firefighters because we don't want to settle with you only to be confronting a lawsuit similar in nature to what you have both on the Medicare and what you anticipate filing on the COLA. Retired Judge Mark Pfeiffer, who was the first state-appointed receiver in Central Falls, was agreed upon as the receiver, and that triggered a number of mediation sessions. And ultimately, it led to a tentative, and I emphasize the word tentative agreement, because as the Retiree Association, we do not represent the retirees. It's not a union, so the retirees are going to be able to vote on this package, if you will. Now, the question I've gotten from the retirees, and the question that may be in your mind, is if you felt so strongly about the Medicare litigation and the anticipated COLA litigation, why did you ever agree to a settlement? And the simple answer to that is the threat of bankruptcy. I advised my clients it was one of those situations that we could lose the case, even though I thought we had a good case, and obviously anyone who's litigated matters will tell you that there's no guaranteed winners. We've all won cases that we should have lost and lost cases we should have won. So that was a possibility, and so if we lost the case, then the city was able to do whatever it wanted to with respect to Medicare and COLAs pursuant to their ordinances. But the more confusing thing for me was that if I won both cases, I actually could be doing a disservice to my clients, and that is, if I won both cases, I wasn't so concerned about the Medicare litigation because that was tantamount to an $8 million savings. I don't think that would have thrown the city into bankruptcy. But the COLA litigation, which I actually thought was a stronger point, especially in light of the fact the way the city went about it by just passing the ordinance without the state enabling act. If I had won that, if I had gone forward and won that, and I may eventually have to try it if the retirees reject this proposal, I think that would have definitely led the city into filing bankruptcy. And if that was the case, all you have to do is look at Central Falls and see what those retirees had. Now, those retirees at one time had approached me, and I have Providence retirees telling me, well, the city isn't going to file bankruptcy, and I tell them the story that I had the Central Falls retirees in my office on a Thursday, and I predicted that there was no way that the governor was going to allow the city of Central Falls to go into bankruptcy, and 5 days later on the Monday, city of Central Falls went into bankruptcy. So that's my prediction rate with respect to bankruptcies. So I can't really count on my crystal ball in deciding whether a municipality is going to go into bankruptcy. I always tell my people, for years when I negotiated contracts for the FOP, and even throughout the state, every municipality tells you they're broke. I've heard that since the early 1970s. I've been doing this since 1972. Now I tell them, they are now telling us the truth for the first time. They really are broke. So, where we stand now with this matter is that there is going to be a meeting where the retirees, 1,300 strong, will be able to vote on this thing. It's being presented at Rhode Island College. The tentative date right now is June 19th. They'll be able to cast their ballot. They'll be able to view it because we have 40% of our retirees are out of state. We have set up a webcast. They'll mail in their ballot. If the vote is to accept the deal, then there will be a settlement agreement, and people will still be allowed to opt out. It's like a class action type lawsuit, so individuals may be able to opt out. There are certain individuals who are governed by the so-called consent judgment, where they got 6%, and there are people who received a decision under the Arena case, which I tried for the retirees, where they got 5%. COLAs were affirmed by the Supreme Court. Those people may opt out because there is no legislation that can supersede a consent judgment or a Supreme Court decision. So those people may elect to opt out and seek their 5 and 6%. But the majority presumably would be covered by the agreement, and hopefully we have saved the day for the city of Providence.
Thank you, Joe. Matthew.
Thank you, Jerry. Good morning, everyone. My name is Matt Oliverio, and I, too, had the privilege of having Professor O'Brien for both macro and microeconomics. It was just a few years after Jerry, though. So there is and has been, over the past 20 years, an emerging and growing tension between that which can be collectively bargained, that which is arbitrable, and that which is sort of sacrosanct under statutory law or granted governmental officials through statutory provisions or charter provisions. And that's really what I want to focus on. I want to focus on really what's happened over the last 20 years and highlight a few of the cases that have come out of both the Superior Court and the Supreme Court in Rhode Island. And I think most practitioners will conclude that there really has been some inconsistency, but a contraction of collective bargaining rights through this process, the judicial process, and when particularly management attorneys find a loophole, find a statute, and advance the arguments that certain topics are not subject to mandatory bargaining, are not arbitrable, and certain duties, rights, and responsibilities cannot be bargained away. Imagine this. Imagine that you have a collective bargaining agreement with a state agency which has a very specific provision pertaining to overtime, that you cannot mandate or force involuntary overtime except in emergency circumstances. Now, you think of overtime. Is that not the subject of bargaining? It involves, under the State Labor Relations Act and the NLRB, wages, hours, salary, and working conditions. Pretty broad, right? So you can't touch that unilaterally. Imagine also that there is state law that governs responsibilities of a state director of corrections. And I'm referring to the Vose case, and this is really the case from 1991 that is relied on heavily by the parties when arguing that a certain subject matter is not arbitrable or cannot be bargained away. The Vose case involved a situation where there was indeed a collective bargaining agreement between the correctional officers and the DOC in which it provided for involuntary overtime assignments only in emergency situations. The Director of Corrections at the time ignored that provision and issued a policy stating that he would adopt a policy where he would determine when and if he would staff force involuntary overtime. And he would do that whether it was emergency or not. And that ultimately went to arbitration, and the arbitrator, faced with a clear contractual provision interpreting that contract, said, hey, state, you lose. There's an express provision here, and I'm going to fine for the correctional officers. That was challenged in court, and it ultimately went up to the Supreme Court. And the Supreme Court stated that the collective bargaining agreement stripped the director of his ability to make and promulgate necessary rules and regulations to exercise his statutory powers. Now, the DOC director relied on his plenary authority, which also was pretty broad, to provide for the safety, discipline, care, and custody of all correctional facilities. That is extremely broad, and yet the court sided with the state in that case and said you cannot impair that right. That is non-delegable, and thus an arbitrator, when faced with that, has absolutely no authority, and in fact, neither the state nor the union had the right to negotiate that term. It kind of left everyone scratching their head, and that was kind of the beginning, and everybody kind of latched on to that decision. So the state thought they'd take a second bite of the apple. About 3 years later, same entities where a correctional officer refused to show up for duty. He didn't provide necessary documentation, and he was terminated. And in that case, the state advanced the same arguments they did under Vose and said, well, wait a second, we have a right to remove someone because that involves the safety, discipline, care, custody of all the correctional facilities, and under Vose, that statutory authority cannot be impaired, cannot be bargained away. In that case, the court disagreed. They said, no, this is not the same situation as Vose. This really involves disciplinary action, which is the penultimate issue for collective bargaining. And the reason why they said it's not the same is because it did not involve a critical area of state power like it did in Vose. A few years later, MHRH was faced with an issue involving consecutive hours. How many consecutive hours can employees work? And these were healthcare employees. And again, in that situation, the director had plenary authority under statutory law and set up a schedule and issued a policy, and that was subject to challenge. And the court there said, you know, this is more like the Vose analysis, because in this case, you are providing a critical function. You're providing for the safety and welfare of disabled custodial patients who are entrusted to the care of the state. So those were some of the state cases. I think the case that really took a lot of people by surprise, and I think you'll all remember this, and Don particularly, because he was involved in it, was the Cranston Crossing Guards case. Okay. Now imagine that, and you see this all the time in municipal contracts, even state contracts, where you may have a no layoff, no furlough, no restructuring provision. So if you have a division of employees, whether they be public works, whether they be library workers, or whether they be crossing guards, if you've entered into concession bargaining, and in this case, the parties did. It was in the early 1990s when Cranston was faced with a fiscal crisis. And I don't know if they've come out of it yet, but they seem to argue that every time they have an arbitration case. Maybe, for good reason, perhaps, for good reason. But so they were faced with a fiscal crisis, and I think they were engaged in concession bargaining. And there was concession bargaining. And in exchange for that, a new collective bargaining agreement with the crossing guards was negotiated. But the quid pro quo was the negotiation of a no layoff, no restructuring clause. Okay, and that was under the O'Leary administration. O'Leary's out, and everyone's favorite mayor, Steve Laffey, comes into office. Sorry, Tom. And of course, the crisis deepens, and he has to take some action. So he reviews the charter, and he finds a provision in the charter, an express provision, which authorizes the mayor, with the approval of the city council, to restructure, reorganize, and organize departments, divisions within the city government as he and the council deem appropriate for the welfare of the citizens of Cranston. And despite the collective bargaining agreement and the prohibition in the collective bargaining agreement, he held that charter provision high. And by the way, the Supreme Court has held that charter provisions have the same force and effect of state law. So when I talk about charters or a state statutory provision like Title 16 involving education, has the same force and effect. So a charter is like state law. And he relied on that. And he also advanced another argument, which was a public policy argument, which was similar to the argument about the non-delegable duties under the charter. And the union, when he laid off these, I think it was 39 crossing guards, Don, what was interesting about that, it wasn't that you just eliminated a whole department, which he did. What he actually did was he privatized the service. So he actually brought in an outside agency to perform the same bargaining unit work that these 39 crossing guards were performing. And that's kind of the head scratcher to me, but we'll get to that in a minute. Maybe Don can address that issue. The union went to court, and they actually got an injunction against the city at that time, and the court referred against the layoffs, and I think the city was trying to prevent arbitration, but the matter ultimately went to arbitration. And similar to the Vose case, the arbitrator said, well, wait a second, you've got it clear? I'm interpreting the collective bargaining agreement. That's my focus. I'm looking at the four corners of the collective bargaining agreement. I'm not looking at anything else. You parties entered into negotiations in good faith, and you negotiated a no restructuring, no layoff clause. So I'm going to enforce it because I'm tasked with interpreting this contract, ignoring the other arguments advanced by the city's attorneys. And although I don't think he came out and said this. What he could have said was, the crossing guard work, according to the petition filed with the State Labor Relations Board, defines the composition of that bargaining unit and the scope of their duties and responsibilities, and you've brought someone in, you've privatized to perform that bargaining unit work. And that violates the State Labor Relations Act. But I don't think he went that far. He said there's a clear contract
Back
provision.
working, Matt. The injunction had issued preventing the layoffs, they were back working, so that injury didn't exist at that time.
Okay, thanks, Don. But they went to arbitration. The arbitration decision came out. Now the city's not happy with it. They said, well, what about our argument about the non-delegable duties? You can't bargain that away. And they had a hearing before Judge Procaccini, and he adopted the rationale advanced by the city, and he said that indeed the essence of city government is the ability through its charter to manage, to organize, to determine, to restructure the size and functions of the various departments. And he also relied heavily on the fact that there was a fiscal crisis that the city was experiencing at the time. Now, remember that. Remember the fiscal issue, because I'm going to tell you about a case that was decided up in the Supreme Court, the North Providence teachers case, where that issue came up, and Justice Robinson said because a certain action was taken for fiscal reasons, that he would not invoke the doctrine of non-delegable duties. But in the interim, I think there was an appeal, and by the time it made it up to the Supreme Court ruled that the issue was now moot. So that was sort of what happened with the Cranston Crossing Guard case, but I'll defer to Don because he was involved in that. And what you see is that a lot of people began to latch on to that case, particularly in the area of privatization. I had a case with John Lydecker not too many years ago where the East Greenwich School Committee decided that they were going to privatize the custodial workers. And I was, according to John, on the wrong side of that argument, and he represented the good folks that had been there for some 30, 40 years, and it was an NEA local. And it was a really hot topic. I made the same arguments that Vin Regasta made in the city of Cranston, the Cranston Crossing Guards case, and we actually went before Judge Gallo in Superior Court. But I think, as John had indicated, you know, these cases, and Joe as well, these cases can go either way.
Thank you for joining us for this edition of Labor Vision. We appreciate your input and encourage your comments. Labor Vision can be seen 3 times each week: Tuesdays at 7 p.m., Thursdays at 8 p.m., and Saturdays at 5 p.m.